David Katz, everybody.
Kim, great to be with you.
Hi. Thank you for being here. I'm sorry Mark isn't here today. He just got back from Washington, D.C., and he got really, really sick this morning, so he is not able to be with us today. Hopefully he'll be with you next week. But thank you for coming on because we have a lot to talk about it when it comes to the Supreme Court. The first thing I wanted to talk about was the fact that they just can't seem to contain their information. We've got another leak about an abortion case. This one about emergency abortions. What's going on? Who's leaking all these things, and why is this happening, David Katz?
Well, first, I'm in a new office. I'm just moving in, so it's a little bit of a mess. So those
Okay.
people who read the tea leaves of what's behind me, nothing, no product placement, just kind of the random move.
Moving
I'm
day. Yep.
sorry to hear about Mark, and my
Yeah.
condolences again. I know he was
Yeah.
very close to his father, who seemed like
Yeah.
just a wonderful man. And I lost my mom in November at 92.
Oh, I'm
Yeah,
sorry.
not just not a good year all the way around on that score. But
Yeah.
there's been a huge amount of news from the U.S. Supreme Court. People are waiting for presidential immunity. They're waiting for whether the marauders committed obstruction of justice, 50 or 60 of them, or are they going to walk if that's all they're charged with. And there's another couple of big cases. There's Chevron deference that we talked about. But they've actually issued a rash of decisions recently. I think the one that people are commenting about, I think it was just a coincidence. They have a very highly trained staff over there, but I think somebody just, hit the wrong button. We're all human. Someone hit the wrong button and they were supposed to put on documents, 1, 2, 3, and 4, and somehow that became the document 4 that was something else was supposed to be put on, and that got put up there. I don't think it's anything on the level of Dobbs. I think the
Okay.
Dobbs decision when they overruled, Roe v. Wade after almost 50 years, and that one leaked.
Mm-hmm.
I've always thought that leaked by one of the conservative justices. That's why I thought running around and grilling law clerks or staff, they could do that till the cows came home, which the marshals did. But the people that they really wanted to question and interrogate were the ones that they couldn't. I thought the conservative justices, one of them leaked it so that they would keep the 5 votes because it was so controversial, and say, you voted for this, say sotto voce, say in the background, not for public disclosure. But hey, we had all 5 votes. Remember that? We have a majority to
Mm-hmm.
overturn Roe v. Wade, including your vote. So don't go back on us. And that's what I always thought was the mystery of that. I have no way of proving that. Supposedly
Yeah.
that was unsolved. But I think that what just happened now was just one of those things that happens in
Yep.
bureaucracies. Let he who has never put the wrong thing on. When they went to
I don't know, David Katz. I think
when
it's
they went to
another.
electronic filing, they gave us a whole big training thing. Don't put your Chinese menu order on there as Exhibit A to your pleadings. Really, really careful.
Don't you think it's weird, though, that it's another abortion case that got leaked? And then I'm reading this story about the Chief Justice of the Wisconsin Supreme Court calling for an investigation after a draft order was leaked showing that they'll take a case brought by Planned Parenthood trying to declare access to abortion a right protected in the Wisconsin state constitution. And that case is also leaked. It's leaked that they're going to even take the case. So you have the leaks coming out, and maybe it's just that they're publicized, these abortion case leaks, but all 3 of these leaks center around abortion. Coincidence? I don't know.
I think it's a coincidence. I think that the Wisconsin one, though, it's a very controversial issue. So I think that Wisconsin state one, that may be somebody leaking it again with an agenda. And I know we didn't really schedule this and don't really have time to talk about if we're going to cover the Supreme Court, but a remarkable case
Yeah.
for people who followed it all these years of a leaker, WikiLeaks, Julian Assange.
Yeah, no, let's talk about it.
Resolution, the resolution of that case. And,
Hmm.
obviously it's incredibly controversial and we can't do it right now. And, the people who say he really was a journalist, and people are furious at him for 2 reasons: the Chelsea Manning and, disclosing stuff. I mean, disclosing who were the, collaborators over there in Afghanistan or Iraq who
Hmm.
worked with us, knowing that they would be slaughtered. It
Right?
seemed to be a terrible use of journalistic discretion. But, that's not what the First Amendment's about. There are going to be a lot of people with their First Amendment rights who are going to exercise what you and I and somebody else might think was terrible discretion. They have this great leak that's going to help Trump get elected. They have this great leak that's going to be terrible for climate change.
Yeah.
They have this great leak that it was the Wuhan lab, that supposedly, by its negligence, sent the virus and covered it up. And still is. So there are people who disclose all sorts of things that are incredibly controversial. And so people like the New York Times and the big media are really worried about the Julian Assange case. The other thing that, of course, makes people nuts is that, the effect of his participation in American politics was he kind of gave us Trump, along with Comey. He kind of gave us Trump. And, to have leaked what he leaked on behalf of, Russians, who obviously were the ones who fished it and then gave it to him right before the election, hurt Hillary really bad. And if you think that Trump was not a great contribution to American politics and to the polity, then that's another thing that, of course, people on the left and in the middle bear against Julian Assange. Having said the whole thing, it was a fascinating resolution at the very last minute. He ends up in Saipan, which is not the continental United States, but for God's sakes, it is the United States, right? It is part of the United States in the Northern Mariana Islands.
Yep.
And it's these plea agreements that I get involved in all the time. They're not nearly as dramatic. They're not usually as fast developing, but it was sort of fascinating. Before the world could kind of react and scream and do whatever, he was out of that awful London prison. He was on that plane that apparently is the same plane that had flown the big star,
Oh.
the big music star. When she went over to London, it cost $500,000 to rent that plane. So they have a.
Are you talking about Taylor Swift?
Swift, yeah.
Okay.
It being the very same plane, some clever person compared the numbers on the plane.
Oh,
So that
wow.
cost $500,000 they're trying to raise by GoFundMe. He also met a lawyer, I guess, while he was holed up in the Ecuadorian embassy for all those years in London. She married him. They have 2 kids together. It's an amazing story. Then he's 5 years in the prison. Then he has those charges from Sweden, which a lot of people think were bogus, that were set up, that it was somebody who was just mad at him or disgruntled or wanted to cooperate. But she made a rape allegation that has since been, I guess, dropped. And then he was supposed to be sent to Sweden to face the music on that. And people said, no, that's really the United States. As soon as he sets foot anywhere outside the Ecuadorian embassy, they're going to bring him over there. And then you remember Trump sang his praises for a while because his information helped Trump so much against Clinton. WikiLeaks, everybody's talking about WikiLeaks. Then once he got power, Trump looked like he was going to try to hail him back here, extradite him, and put him in prison for the rest of his life. And so it's a fascinating story. But the one thing that I want to talk about, because I'm a criminal defense attorney, is that you have to enter a guilty plea under oath in federal court. State court always featured these people, Kim, who came out of the courtroom and said, man, I'm as innocent as the day is long. I didn't do anything. My dump truck lawyer told me to take this deal. I didn't want to spend time in jail. But I am innocent. You don't come out of federal court and say that, because in federal court, you get put under oath. They say, you understand, you're telling me what happened under penalty of perjury. And then you state your factual basis under oath. And Julian Assange did that like everyone else. And people say, my God, with the pressure of spending the rest of your life in jail, a lot of people would take that oath and say they did something and be lying under oath. But you do have the greater complication that you're lying under oath. And then your attorney has to make an inquiry. And they say to your attorney, do you believe there's a legal and factual basis for this plea? So my point is just that the federal government did an awful lot to bolster this case and to bolster this guilty plea. So when Assange or Assange's family turns around and says, I'm as innocent as the day is long, I'm just a journalist, he's going to have to also say, and I had to do what I had to do to get out of this. So yes, I falsely testified under oath that I did it, but I didn't do it. And the gist of what he did wrong, if you take the prosecution point of view, is that he wasn't just a journalist. Like somebody calls you up right now and says, Kim, I saw you on a podcast. You seem like an honest person. You seem like someone I can trust. Here's these great secrets from the CIA or from the National Security Agency or something like that. His case is that, no, you worked somebody inside the government. You solicited it from them. You knew very well they were violating the law. You kept encouraging them to violate the law. Give me those documents. I'll hide it. You won't get caught. Here's the plot, all this kind of stuff. And that is the government's argument for why this is not just news gathering and why Assange was not just doing a journalistic function. But the case is as controversial as it can be, and it's suddenly over like in a flash.
Like that. Yeah.
Yeah, I just wanted to make sure that we talked about Julian.
Credit for time served, and he's done.
He's back in Australia, probably not saying good things about the United States. And of course,
Mm.
some people in the United States are not saying good things about him because, yes, we should have the government in transparency, right? We should have a transparent government. But people have pointed out that if he had done in Australia with Australian documents what he did in the US with our US documents, he would be serving the rest of his life in prison
Wow.
in Australia.
Yeah.
A
Yeah.
little hypocritical.
Can we talk about this Supreme Court ruling that came down yesterday? Because I'm flabbergasted by the nonsensical nature of it. It's about public corruption. And what they said is basically, in a nutshell, you can have your bribe after you do the favor, but not before you do the favor. So if I say, hey, David Katz, I'd really like you to, if you're the judge, I'd really like you to rule in my favor. And I'm going to give you, I don't know, a house bus and I'll pay for your child's education. I can't do it before you do me the favor. But after you do me the favor as a thank you gift, well, that's okay. Does that make any sense? Am I getting this right?
If you're a cynic, the six justices on the U.S. Supreme Court who ruled this way, they're just looking at the mirror. They're looking in the mirror and they're saying to themselves, if I rule in favor of some big, huge corporate interest who has a case before the U.S. Supreme Court, and I ruled in their favor, and then a couple of years later, I went on a salmon fishing trip with them, like Alito did, do
Mm-hmm.
I want the same charge to be made against me? So if you're a cynic, the six of them were just looking in the mirror, the six in the majority, and saying, you know what, this could have been me. Because there's a lot of things that especially Thomas and Alito have done that could be characterized as gratuities that they took after ruling in favor of people where it involved an awful lot of money. Of course, they don't have in those cases, presumably, any quid pro quo where anyone said to Thomas, I'll give you all these wonderful things if you vote straight down the line in conformity with my corporate and personal interests like these billionaires have done. That's if you're a cynic. It has the same breakdown that we're used to seeing right now. You have, Jackson, Kagan, and Sotomayor in dissent, saying this is an absurd reading of the statute. The way you get there is this: if there's a state statute which gets you convicted of corruption in state court, fine. And if there's a local rule that bars this, that's fine. You can be a local official charged in a local court. You can be a state official charged in state court under state law. The Supreme Court didn't reach that. The Supreme Court reached a federal statute that says that you cannot corruptly. And so they had to define what does corruptly mean. And they said, well, a quid pro quo bribe is obviously corrupt. Everybody would understand that that's corrupt. But these things that you get later on, what did you call them again? The things that you get afterwards.
A thank you gift?
A thank you gift. Yeah. Yeah. There's a word that they use in the opinion. There's so many opinions that just
Yeah.
came out. But the later thank you gift
Yeah.
is one that they said local and state officials would have to guess. And if they guess wrong, they could do 10 years in federal prison, whether receiving something afterwards is a corrupt receipt of something. And it was 13,000. The facts of the case are kind of interesting. This fellow is the mayor of a little town in Indiana. I think it's Indiana.
Mm-hmm.
He approves buying a bunch of garbage trucks. The company that buys $1 million worth of garbage trucks, like a year after this, when I think he is still in office. Anyway, a year after the law is passed and the city buys the garbage truck, some months after that, they give him $13,000. His defense on the facts is that he was consulting for them. He got to know an awful lot about this. His consultation, I don't know the facts enough to know whether he's got hours to prove, okay, he charges $200 an hour. He worked that many hours. He met with that many people. He did that much consulting. This may be a total nonsense defense that the jury didn't buy, because the jury did convict him at a jury trial. And he went all the way to the U.S. Supreme Court and got his get out of jail free card. When he finally got to the U.S. Supreme Court, 6-3, he was on his way to prison for over a year, federal prison, until he finally won. And Kavanaugh wrote the decision, and Kavanaugh made an argument I thought was very unconvincing. He said, well, okay, so let's say you're in high school and you really like your high school teacher, and you take your high school teacher out after the year is over for a graduation dinner. 13,000 is not a graduation dinner. Then he
No.
said, suppose you take him out to a Hoosiers game. I don't know. I guess that's the basketball team. Let's
Yeah.
say the ticket costs $100. $100 ticket for your teacher or coach after the season over is still not $13,000. So the fact that he used these hypothetical examples that were not very persuasive, I would have ruled the other way on the case. I think it's
Yeah.
very clear. I also think you hire a lawyer. That's what people do. You hire a lawyer and you say, look, I want you to interpret federal law. I've been offered this $13,000. If you tell me I should give it back, I'll give it back. If you tell me it's lawful for me to keep it. So the idea that it's so hard to figure out in all of these states, the guy was smart enough to get elected mayor. He's smart enough to hire a lawyer and figure out gratuity. If this gratuity, this after the fact gratuity, violated the federal laws. Now, of course, Congress could turn around tomorrow and make this crystal clear. But, they're very slow to deal with some things like insider trading. And the Congress people, a lot of them, if you're a cynic, you think when they vote on something like this, they look in the mirror and they
Right.
say to themselves, right, how clear do I want this to be if this is going to come back and bite me?
Well, and it seems like you would be smart enough. I mean, in the scheme of things in 2024, $13,000, it's a lot of money, but it's not enough money to go, if I take this money, it's going to have a real bad look for me. It's going to have the look of impropriety. It's going to look like I was on the take. Is $13,000 worth that? And I would say it's a lot different from $100 gift for a teacher, for a thank you gift for the whole year of, teaching me things and whatever else. And the grades have already been sent in. It just seems different. This seems more of a, I'll give you this contract, you scratch my back, I scratch yours kind of situation. And I don't think it's very smart to take anything from a company like that. But I know that's the way politics is done.
Well, the government's proof is allegedly that this mayor was totally in the tank for this garbage truck company, and there was never competitive bidding, and he made sure it went to them. So, like I said, Congress could change that. Congress could change the law and make it clear that the federal bribery statute. This has been a series of cases which have cut back the reach of federal bribery laws.
Of course.
There was the case that the Virginia governor won. The Virginia governor, his case went to the U.S. Supreme Court, and I think unanimously they said there had to be more of a quid pro quo. Bridgegate, that issue, I think went to the U.S. Supreme Court, not with Governor Chris Christie, who was, of course, a prime suspect for criminal corruption. It's fun to see him lecture the world, but Governor Christie was that close, to being federally indicted in that Bridgegate, where his political enemy had the control of the area right next to the bridge, and so he shut off access to the bridge. And allegedly, he didn't know what was going on. His aides did it. His aides got in trouble for it. And there's a fascinating story. This FBI agent that everybody is blasting on the right, he was a criminal defense lawyer. And I'm never against a criminal defense lawyer getting $7 million, but he got over $7 million as the criminal defense attorney for Governor Chris Christie, because Governor Chris Christie could control the public fisc. So if you want to know where your New Jersey taxes go, over $7 million went to our current FBI director when he was a criminal defense attorney for Chris Christie.
Wow.
But it was also cut back in that case. And so I think if you're a cynic, you just think, wow, I mean, they're making it awfully hard to get public officials for bribery. And I mean, you should be Caesar's wife. I guarantee you, when I was an assistant U.S. attorney, you didn't take anything from anybody, not while you were in office, not after you left office. I mean, come on, this is just certainly in terms of public ethics. And all these people, if what they're doing is supposedly confusing, I mean, it's grifting. It infuriates people. If you're going to have public office, do the public business. Now, if you can go out later on because you have so many skills, people say, well, David Katz, you're a hypocrite. You guys leave the U.S. Attorney's Office and you make money as criminal defense attorneys. But we don't make money on the cases that we handled when we were defense attorneys. We get an area of expertise that is generally applicable to a person in federal criminal trouble. And then we represent people we represent people who are not at all the people that we prosecuted.
I know that as a judge and a panel that used to be as respected as the Supreme Court of the United States, you consider each case and the merits of each case and not overarching politics. But it seems to me that at a time when you've got the Supreme Court, certain members being accused of being on the take, and ethics has been a huge issue for this particular panel, that maybe making this particular ruling, that wasn't so wise for them, because it leaves another bad taste in people's mouths.
If taking these, yeah, I mean, I agree with you. I agree. Let's go on to some of the other cases. A lot of others.
Okay. Well, how about this one that just popped up? Judge Cannon is at it again. She's pushing back on the idea that having more hearings in the Trump documents case in Florida will actually delay the case. So she is not happy with this. She wants to hold additional hearings on Trump's attempts to challenge key evidence in this documents case, and is going to allow Trump's lawyers to question witnesses about the investigation and the search of Mar-a-Lago. And today, she said in a new order, she wants more evidence about the language in the FBI warrant used to seize classified records at Mar-a-Lago in 2022, and about the grand jury testimony from Trump's former attorney. And she's saying, listen, having more hearings in the case isn't going to delay it. That doesn't make sense, does it?
I think that what's happening here, people thought that this was going to be, and it normally would be, an opportunity to bring out the violations of law that Trump committed. He took these documents with him when he went out of the White House. That was one reason why there's venue in Washington, D.C., because it all began in Washington, D.C., on or just after January 20th, 2021, when he left office. But it's clear that he took them, he didn't take them just anywhere. He took them from Washington, D.C. to Mar-a-Lago. And then he obstructed justice when he got subpoenas and requests to return them from Washington, D.C. And then he got two of his minions involved in it, allegedly. And they did most of what they did in, Fort Pierce in that Mar-a-Lago area of Florida. But they also knew that there were lawyers hired to deal with this Washington, D.C. subpoena, this request from Washington, D.C. to get the documents back. So that's why a lot of commentators like me have said there was perfectly good venue in Washington, D.C., and the case should have been brought there. Having now been brought there, Jack Smith, I think, has to see the case in a totally different perspective. And the perspective is this case is not going to result in the embarrassment of Trump that he did things wrong and violated the law anytime before the election. What we're seeing, I think, pretty clearly is that Judge Cannon, who was handpicked by him, and I think dreams of herself as being Justice Cannon, and why not? If there are 52 Republican senators, why not?
Oh, could you imagine? Oh, man.
I can absolutely imagine it. There's no doubt in my mind I'll imagine. She was born abroad. He'll say this is a great step forward for the U.S. Supreme Court. We finally have a justice who was born abroad. All the people who are immigrants to this country, here's a justice who's just like you. Oh, he'll mark it up like it's the greatest thing in the world when he puts Justice Cannon on there. So I think that if he wins, and he has 52 or 51 Republican senators. So I think that what's happening, well, if he won, he only needs 50 Republican senators and his vice president, if they all, go along with her. And why wouldn't they? So I think that what she's going to do is use this as much as she can to embarrass Jack Smith, to call as many witnesses that Trump's lawyers want to talk about, oh, did they lie in the affidavit? Did they make it sound like they were going to shoot Trump? This is complete nonsense. Anybody who's been a federal prosecutor or criminal defense attorney has seen these boilerplate things. And they go through all these different contingencies. Yes, they're too long, and they go through too many contingencies. And if you want to make a big deal out of some little clause, you can. So this one dealt with the issue of, well, can we use deadly force? And the answer is no. No, we can't use deadly force, except if A, B, or C happens. Okay, A, B, and C were never going to happen. Among other things, they executed the search warrant when Trump and his family weren't even there. Trump and his family weren't even there. So the idea that they were going to somehow use this boilerplate language as an excuse when Trump, raised his hand and they were going to shoot him dead, so the FBI was there to assassinate him. This is complete and total garbage. The Republicans in Congress want to cut the FBI. They'll never get it. But their new bill wants to cut the FBI. They want to cut Department of Justice lawyers, not the special prosecutor, because they can't do that. All Justice Department lawyers, civil rights lawyers, Civil ones, if you sue the United States on a totally bogus claim, thank God, or a good claim, thank God they have attorneys who represent us taxpayers so we don't just go shelling out money. The
Sure.
lawyers who represent us, they want to cut them 20%. The civil rights lawyers, every lawyer you can think of at the Department of Justice, natural resources, all of them 20%. They want to cut the U.S. Attorney's Office 11% throughout the country. Now, you can laugh. It seems that every case that I get 2 assistant U.S. attorneys. I consider that flattering in a way. But why do I always have to? I'm one person. Why do I always have 2 assistant U.S. attorneys against me? Well, I'm flattered. Beat 2 as easily as you can beat 1. So yes, do they overstaff cases? Yes. Do they bring some stupid cases? Yes. But to cut the U.S. Attorney's Office 11% throughout the country when the population's growing, this is all this is this, they have this thing called lawfare, and they've convinced themselves that the Department of Justice has been weaponized. And let me just say this is amazing, because I was there for Carter, and people joke that Carter was such a non-politicized president. It seemed like he only indicted Democrats. And if you added it up, it seemed like our Democratic president, Jimmy Carter, only indicted Democrats. In the Abscam congressional scandal, Kim, he indicted only 1 Republican Congress member, and he indicted like 7 or 8. There's a movie called American Hustle, which talks about the Abscam investigation. It's a good movie. And they indicted like 8. And that's the same thing now with Biden. Senator Menendez, he's a Democrat, right? He was the head of the Foreign Relations Committee for the Democrats when he was indicted. There's this guy Cuellar down in Texas somewhere. He's just been indicted. He's a Democrat. There's all these Democratic mayors. They seem to be after Mayor Adams. That's the one that gets me on TV on Fox in New York all the time, talking about Mayor Adams. They seem to be on this guy who's a Democrat under a Democratic administration. So it's all made up. You're going to see it today with the debate showing up too. That's all they're talking all the time. Weaponization of the Department of Justice. And it's just false, Kim. It's just factually false.
It is false, but they say it enough and people actually believe that stuff. Even though you can turn around and have these examples of Democrats who have allegedly committed these crimes and are now facing the music. If there was a weaponization, then you would be circling the wagons to protect your own, not holding people accountable to the law regardless of party.
So true.
Back to Cannon for just a moment, because I wonder, you said something that kind of made me start thinking when she's talking about, I don't know, when she seems to be so partisan. How partisan can a judge be before they are hauled into some type of, I don't know, if it's the bar that would handle justices, or if there's another organization that handles the ethics of judges? How bad does it have to be? How one-sided and maybe unfair does it have to look before you get somehow reprimanded or taken off the bench?
Well, if a judge does something blatantly corrupt and gets caught, there have been some federal judges who haven't even filed a tax return or have underpaid their taxes so grossly that their case became a federal criminal tax case, just like if they weren't a judge. But there are very, very few. If you look beyond you take like the impeachment of federal judges, because the Senate does have to impeach a federal judge. If they just won't resign and they won't leave, they have a life term. And so the only way to really get rid of them, they could, I guess, even be in federal prison. But to actually get rid of them, to end their life term, you'd have to impeach them and then convict them in the Senate. So when people talk about impeachment, and Trump was impeached twice, but not convicted by the Senate twice, the paradigm of those cases is the federal judges. And if you look at they're almost all tax cases. So to answer your question, there's almost nothing that you can do that will get you impeached. In terms of being brought up in front of the bar, that's mainly a thing for lawyers. That's not really a thing for judges. You see that in California, people make complaints and there's a judicial commission and they're pretty vigorous in a lot of states. There's really nothing like that in the federal system. They have life tenure, and the only way they can get removed is impeachment. You see some other things where some group of judges may decide that some judge is so senile that they're going to not direct the case to that judge. And I haven't seen many of those actually being challenged. Some judge who says, I think there was one who said, I'm not senile. That may have been in state court. And she took her case to some judicial commission and said, I'm not senile. Let me prove it to you. And they tried to prove that she was senile. So this thing with Cannon, where the chief judge, for instance, said to her, it might be the better part of discretion to let this go to a more senior judge. The optics of this are not good. That chief judge had no power to do that. And if she never gives up that case and the optics get even worse, she won't be subject to discipline or removal. The
Wow.
only way she can really get removed from the case is it goes up to the higher court, and the higher court, normally as part of reversing some decision, says, this is like if she got reversed, it would be the third time. So the Court of Appeals would say, look, you've shown this sort of willful disregard for our orders. We're telling you to do these things, especially if it were the same, but it wouldn't be the same because her two earlier decisions, Kim, were about the search warrants. This will be about something else probably.
Mm-hmm.
But if you sent a case back to a judge twice and you said, do this thing right, and they did it wrong the third time, you would expect the Court of Appeals to not only reverse that decision, getting it wrong the third time, but to say, it would be better to assign this at random to a different judge. And then they would pick a judge off the wheel. And there was 1 in 3 chances of going to her. So there'd be only be 2 judges left. So they would pick one of the other 2 judges, and it would go to them. But to answer your question, I know it's kind of a boring and long-winded, but
No.
they're not getting rid of her. They are not getting rid of her. And you made a great comment the other day. You said, well, maybe they just, could go on without her somewhere else.
Right.
And I think that that's possible. I mean, let's all be realistic. If Trump gets back into office, he'll tell the attorney general, don't prosecute this case any longer. And that'll be it. There'll be nobody to prosecute it. His attorney general won't appoint any new special prosecutor. And that'll be the end of it. For warrant of prosecution, there'll be no further prosecution. Likewise with the January 6th case in Washington, D.C. If he does win again, hope springs eternal, I'm sure, in wannabe Justice Cannon's mind. He'll get back in there in another 4 years, and if she's young enough, he'll put me on the Supreme Court then. That, I think, might be the moment. Trump loses, right? I think that might be the moment to really just to really move on, to just file a case either in Washington, D.C., or if there's venue in New Jersey, bring the case there and explain to the court there that, it's not like we've done a whole lot here. So I guess I wouldn't be surprised. I don't think you're ever going to read this in some memo or some Freedom of Information Act document that you get a hold of. But I wouldn't be surprised if Smith said to himself, we're never getting to trial. Why are we pushing so hard? All we're having is hearings. We're having endless hearings where FBI agents are called to the stand and said, what did you have for breakfast the morning of the search? And what did you do then? Trying to show that they lied in some affidavit. I just don't think he's getting, at this point, I think he's got to say to himself, I'm getting nowhere productive by pushing this case to trial by November, because it ain't going to trial by November in front of her.
They're just they're wasting the taxpayers' money at this point because it's this endless cycle.
And I think trying to help Trump try to embarrass the government. I mean, sometimes the government does things wrong. I made these requests for Frank's hearings. You can imagine a situation, I don't think it's this case at all, but you can imagine this great land of ours with all the cases that are going. There is some FBI agent, some IRS special agent who wants to get somebody, right? And maybe for the best of reasons, they think the person's gotten away with it 2 or 3 times. And instead of being fair in the affidavit, they stick their finger on the scale, right? They make up some fact or they misconstrue some fact, and you catch them, right? And you say, hey, if they told the truth to the magistrate judge wouldn't have issued the warrant. And if they hadn't issued the warrant, they wouldn't have this inculpatory evidence against my client. So the remedy is fair, right? If you step on the foul line, you don't get to score the goal. You stepped on the foul line, the goal doesn't count. That's the exclusionary rule. But boy, I don't think that, I used to argue with Laura Ingraham on her show about the FISA footnote. And she thought that was the worst lie that had ever been told in an affidavit. And boy, if those special judges had known that before they issued that foreign surveillance warrant, they never would have issued that warrant if they didn't know that Hillary Clinton ever even thought of. No, that was an overwhelming reason to issue that warrant for that guy who was on Trump's staff, remember, in 2016, who looked like he was a Russian agent. Whether he was or he wasn't, you can see why the government moved on that. He may have been totally innocent, but there was more than probable cause, in my opinion, and in the opinion of that FISA court. And remember, that was the cause célèbre, that if they'd have known some of the research had been done. So anyway, I get attacking search warrants. I get that sometimes agents, make things up in them, and that defense attorneys be conscientious and try to attack them. But I think this is going to be used. They always say it's a show trial on Trump. I think Cannon and Trump's lawyers are going to try to turn this for the next few months into a show trial on what the FBI supposedly did wrong. And I just don't think, from what I've seen, they did anything wrong. I think they gave Trump a huge amount of time to get right with the law, They hope not to charge him. They just wanted to get the stuff back because it was national security. And he tried to make a monkey out of them, including they ended up showing the crime fraud exception, Kim, applied to his lawyer. Remember that? You
Yep.
normally cannot interrogate a lawyer about what the client said. But if you're trying to commit a crime or a fraud in the future, with a lawyer, the fact that he has a bar or she has a bar license doesn't mean, oh, that's the person I can go commit a crime with. You can't go
No.
commit a crime in the future and plot to do it with anyone, whether they have a bar card or they don't have a bar card. If they have a bar card, they have to testify like everyone else
Yeah.
if the government shows that the crime fraud exception applied, and so the attorney-client privilege doesn't cover it. But I think this is going to be turned into a show trial a la Cannon, a la Trump lawyer.
Well, speaking of shows, we've got the debate coming tonight. And a couple of days ago, the judge in the hush money trial partially lifted the gag order, which means that maybe, as Trump is, going off down the garden path when he starts speaking tonight, he may be able to say some things. And I wonder how much if of what he says could be used in any of the cases against him. Does he have to be really careful, or can he just say, listen, freedom of speech, I can say whatever I want? Or can all of the things that the potential things he says at the debate be turned around and used in the all of these pending legal cases?
I don't think much of it can be used against him. I mean, if you go case by case, obviously, if he defamed that Jean, what's her last name again?
Carol, E.
Yeah,
Jean Carroll. Mm-hmm.
no, if he defamed E. Jean Carroll during the
Yeah.
debate, she'd sock him for another $500 million. He just can't be that foolish and self-destructive. I don't know. Maybe he can be. He's done things that I thought were that any forget whether you agree with him or not, that any sensible person, even a sensible demagogue like him. So, but I don't think he's going to do that. And then as to the jurors, I mean, if he blurts out, Joe Smith, he was the worst of them. That guy is a lawyer. They never should have let a lawyer on them. That guy's got to practice, and he's a civil rights lawyer, and he hates me. And Joe Smith, well, yeah, he's going to be in contempt if
Sure.
he does that, because he cannot reveal that much about any of the jurors. But he can blast back at Michael Cohen. I always thought it was a mistake, given how Michael Cohen and Stormy Daniels were blasting him in the media, that they were covered by the gag order. I thought that gave him rope. I thought Judge Marchand was terrific in New York. I thought on a couple of things, he just couldn't quite get his mind around it fast enough how Trump was playing him. And I thought the two things he got played on a little bit was imposing a gag order that didn't exempt Michael Cohen and Stormy Daniels. Let Trump say whatever he wanted about them. They were saying whatever they wanted about him.
Sure.
And I thought the other one was making him sit there in the courtroom. I always thought that if the judge had said to him, look, you're running for president, I don't want anyone to even argue that I'm interfering with you. Yes, you normally have to be in my courtroom. But for this, if you need to be somewhere else, you go and be somewhere else. Just, make sure you report in. Trump would have been there almost every day. He wanted to be there to confront Michael Cohen. He wanted to be there to confront Stormy Daniels. He wanted to be there to glare at some of the witnesses. And the one that I would have loved was if they had called if they had called Michael Cohen the same day he wanted to go to his high school kids' graduation.
Yeah.
Why do I think if allowed to do whatever he wanted to, he would have rather
shown up.
glared at Michael Cohen?
Absolutely. Lastly, I want to ask you about this Purdue Pharma case, because the Supreme Court ruled today that the settlement in this case inappropriately included legal protections for the Sackler family. They were the owners of Purdue. And it threatens billions of dollars that it secured for the victims in this settlement case. So, I mean, I guess there were some mistakes made?
In terms of a surprise, the surprise today was that the most recent appointee, Jackson, the one appointed by Biden, African-American, she was the decisive vote which said, no, I am not approving this bankruptcy settlement. And it's sort of an amazing lineup, because if you believe that these plaintiffs will end up getting more than $6 billion in their hands, real money from the Sacklers, fine. But if you're a realist and you say, $6 billion, not bad. The tribes needed the money, they signed off. All these states need the money for, remediation of all of these addicts created by the Sackler family and their opioids, right? They need remediation. They need money. There's real uses for this $6 billion. And Kagan and Sotomayor said they need the money. I think Sotomayor joined her. But I think Jackson had just stuck in her craw. She said, these people probably have $20 billion. They have $20 billion. Why should they pay only $6? This is such imperfect justice, what they did in the bankruptcy court. And the bankruptcy judge had said, bankruptcy court, it's always a mess. It's always a compromise. You don't get all your money and you don't get perfect justice in the bankruptcy court. But they got enough, this $6 billion, that an awful lot of people joined this settlement and said, this is what you should do. So I sure hope that Jackson is right, and I hope that the majority is right, because right now, unless they make some new deal, right, the tribes are not getting the money, the plaintiffs are not getting the money. The $6 billion fell. When the deal fell, the $6 billion fell. And that's why I say, unless you're pretty sure that they're going to collect more than $6 billion, they're going to try. They've sued them. They're going to attach assets. But, people can, in this world, people send money abroad. They have trusts. Whenever they do something like the Panama Papers, or they get these Swiss bank accounts because there's some whistleblower, you find like billions of dollars that people have hidden, and you don't know that it's hidden, right? That's the whole idea of hiding it. So, as I say, I'll agree with Jackson, and I'll agree with the majority here throwing the whole thing out if, but only if, I see that they get more than $6 billion out of the settlers. There's a lot of very, very unhappy people. You can say, well, they're unhappy plaintiffs' lawyers because they were going to get 30%, 40% of the money. I get it. But the lawyers weren't going to get all the money. The tribes, the states that need the money, the people that need remediation from opioid addiction, were going to get billions and billions of dollars, and now they're not going to get it. Hugely controversial decision.
It's interesting, and I know I've kept you too long, but you've mentioned Ketanji Brown Jackson, and she was the justice who wrote the opinion on the public corruption case as well. And she wrote that it was a decision only today's court could love. She said greed makes governments at every level less responsive, less efficient, and less trustworthy from the perspective of the communities they serve, and that the absurd atextual reading of the statute is a decision only today's court could love.
That's back on the gratuities.
Yeah.
But again, that's interpreting the word corrupt. Congress would make it very, very clear that you can get prosecuted for accepting gratuities. Let's hope that, at least in my opinion, I think Congress should move in that direction, because $13,000 after you've made the decision as mayor to buy those trucks and you're getting money from the trucks company, that's not like getting tickets to the Hoosiers game because, to serve with love, you've been such a great influence on your high school students. Right. They're buying you a Hoosiers ticket. Listen,
David
it's
Katz,
great to be with you.
I love you. Thank you for coming on the show, and I always learn so much when you do. We'll see you next week, and thank you so much for being here. Good luck with the move.
Thank you. And next week is going to be presidential immunity. So tune in. We're going to have a lot to talk about next week.
Oh, and we have to decide if we're going to do it next week, because we have, I think it's July 4th next Tuesday. Am I right? 4th of July?
I'll be here.
You'll be here.
I'm happy to do the show.
Okay.
You bring the fireworks, and we'll talk about
the fireworks, the hot dogs, and American justice.
And I think it'll be really, there's 2 or 3 other really interesting cases. The Chevron deference that we talked about a lot. Administrative law sounds very, very boring, but when it's the environment and you have to breathe it and live with the global warming, it's suddenly very, very interesting if these Republicans on the Supreme Court cutting back on our environmental protections.
Yeah. Absolutely. Thank you, David Katz. I appreciate you.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.